the Norwegian Nobel Prize Committee decided to award the Nobel Prize for Peace in 2015 to the Tunisian National Dialogue Quartet. The winning quartet is composed of the Tunisian General Labor Union, Tunisian Confederation of Industry, Trade and Handicrafts, Tunisian Human Rights League, and the Tunisian Order of Lawyers. The reason to award the Nobel Prize for Peace to the quartet was its commitment, this is from the press release, a commitment in a peaceful political process at a time when the country was on the brink of civil war. The role of the quartet in the political process was decisive, and it led to establishing, again from the press release, establishing of a constitutional system of government guaranteeing fundamental rights for the entire population, irrespective of gender, political conviction, or religious belief. The provisions of the 2014 Tunisian constitution deserve the praise they were given. The Republic of Tunisia is based on popular sovereignty as provided by Article 3 of the Constitution. The Constitution of the Republic encompasses a wide catalogue of rights and freedoms guaranteed to all citizens, Articles 21 to 49. The organization of power follows the concept of semi-presidential government with a double-headed executive. The citizens elect the members of one-chamber parliament as well as the president of the republic in a direct ballot. The Council of Ministers is accountable to the parliament. It is also worth noting that the Constitution provides, and I quote, on the neutrality of mosques and places of worship from all partisan instrumentalization, as provided for Article 6 of the Constitution. The Constitution departs from reality. It has been drafted for a country with a strong Islamic majority that follow respective religious traditions. However, its starting point is a tolerant approach to religious life, for it reads in the preamble, and I quote, expressing our people's commitment to the teaching of Islam, to their spirit of openness and tolerance, etc., etc. To sum up, the drafters of the Constitution have managed to transplant to the Tunisian society the institutions of political democracy, as well as the concepts of human rights protection and social justice perceived in a modern way. Their achievement is considerable. Those who helped them succeed on the arduous path of constructing the constitutional system of the country deserve the prize they were awarded, and they were handed over the prize only 2 or 3 days ago. Now, if we turn to the merits of the quartet contribution to the peace process and constitution making, considering it on a somewhat broader scale, it seems indispensable to underline a special technique which was at the origin of their efforts. It may seem surprising to some extent, but that technique is comparison. It was indeed legal comparison that inspired the drafting of the Constitution and adopting its text in the Constituent Assembly. The 2014 Constitution itself is a specific and a rather complex legal transplant. Legal transplants rely on previous comparative studies they use as pretext and in which they find a pattern to follow. That is why we're allowed to conclude that in this particular case, it is the comparative law at the origin of the peacemaking as embodied in the constitutional drafting. Comparative law has a specific task. To paraphrase Philippe Legrand, its function is to provide knowledge to those who study law beyond the empire of texts and enable the student to realize the limits and deficiencies of his or her national law. That is what makes legal comparison a desired beginning and the proper foundation of the study of law in general. Comparison creates a critical attitude towards the object of the study. It provides a viewpoint from which the truth can be perceived. That is the reason why comparative law and legal comparison should be at the very beginning of the study of law and give the tone to the whole study. Legal comparison has nowadays spread into many fields of law and legal activities. It inspires legal practice, and it has also influenced the administration of justice. The phenomenon, which is called judicial cross-fertilization, consists in using legal arguments of foreign jurisdictions when trying cases under a national law of a modern state. It is indeed the argument that bears the value and not the fact where a certain legal source finds its origin. It is not important whether a legal provision stems from the national or foreign legislation, or whether a precedent invoked is from the domestic legal system or of foreign origin. Justices compare their national sources of law to those of others and have therefore developed a comparative law approach to their task. The growth of such practices, also known under the name of the dialogue of judges, has become so considerable that some scholars go as far as to speak of a legal revolution. The practice of the dialogue of judges spread to the international jurisdictions, among which the European Court of Human Rights can well serve as an example. The judges at the international level invoke national precedents to provide reasoning for their rulings. The European judges refer to the precedents stemming from jurisdictions outside the member states of the Council of Europe. A small example can illustrate this. In the case of Sukhovietsky versus Ukraine, it's a case of 2006, the applicant complained under Article 3 of the first additional protocol to the European Convention on Human Rights about the amount of deposit one had to pay to stand in the elections. The European Court of Human Rights based its ruling, inter alia, on the judgments given by national courts of law in Ireland, Canada, and Mauritius. It does not matter for our purpose here whether the European Court ruled for the applicant or not. What is important is the method of consulting precedents on a world scale. By the way, the authorities from the three countries mentioned were contradictory, and the European Court had to choose and decide. The example brings us to conclude that legal comparison of such a magnitude indeed creates a bridge connecting countries and peoples. The topic is what matters, the legal question and the issue of being right or wrong in a legal dispute. That is what requires a solution through an adequate approach. In Ukraine, where the case was from, or in Ireland, Canada, or Mauritius, the issue was fairly comparable, and the European judges felt comfortable to invoke precedents from the different parts of the globe. If we are to agree that comparison in general, and legal comparison in particular, establishes connections between peoples, it means that the comparative law's outstanding contribution to social developments is laid down in its method. The mode to proceed in legal comparison can simply be described as the comprehensive insight into the behavior of others. The fact of mere understanding is what precedes each and every comparison. We are confronted to others on many occasions, and if others are not understood, they may remain unknown or even mysterious, which as a consequence may create insecurity in our mind. Once upon a time, at the dawn of civilization, communities of human beings lived isolated. Their contacts were few, and even when the contacts occurred, peoples were hostile to one another for the most part. The other was then someone to confront with. Our psychological heritage is therefore troublesome. It certainly needs modulating and improvement, and they both begin with the simple fact of meeting our fellow men. Meeting someone open-mindedly means discovering the other, which on the other hand brings more knowledge of our own self. Those who discover others get enormously enriched. Robert Burns was right. I don't know whether his lordship is here. I'm sorry I cannot pronounce the words in the Scottish original. Robert Burns posed the question, would some power give us the gift to see ourselves as others see us. With the experience of centuries that has marked our civilization, we could claim we do not need the divine power for that particular purpose. Men and women have managed to construct bridges to communicate and learn about one another. They can use those to step over troubled waters with a sufficient amount of security. One of those bridges leads to comparison as a mode of understanding and the foundations of our knowledge. That is why, by implementing legal comparison, we can certainly understand the world better. But the world we live in is fairly complicated and heavily burdened with conflicts, which are for their part complex and cannot be easily resolved. The comparative law has stepped in to help finding a solution on many occasions. One of the paths to the solutions seemed to be what is called constitutional engineering. The term has been criticized, as well as the practice standing behind it. The name does remind of ethnic engineering, which is of course repulsive and completely unacceptable. However, not each and every practice of engineering in the society should inevitably be labeled as odious. Constitutional engineering may bring fruits of different values. It may or may not turn out to be successful in a particular situation. But even when less advanced than it was desired to be, it does appear to be a remedy that can cure a disease, at least to some extent. One of the examples of that kind is the Constitution of Bosnia and Herzegovina, which is a part of a treaty that is Annex 4. The Constitution is Annex 4 of the General Framework Agreement for Peace in Bosnia and Herzegovina, also known as the Dayton Agreement. That constitution has been subject to criticism. It has been rightly observed that the state of Bosnia and Herzegovina does not function well. The institutions of government do not always operate in the way they should, and the constitution of the country should be subject to debate, political negotiations, and eventually amendment process. That is all true, but one must not disregard the fact that the constitution of Bosnia and Herzegovina, imperfect as it is, has secured peace to the country for 20 years now. The Dayton Agreement was signed on the 14th of December 1995. It is indeed the political settlement that laid down the institutional framework enabling the process of searching political solutions to the problems that not so long ago were to be solved with arms in hand. The Constitution of Bosnia and Herzegovina was not only a legal transplant. It provides for modern institutions of government that have been inwrought into the social tissue of the country in a rather delicate way. It required a lot of imagination and the creative approach of the drafters, diplomats, and lawyers to cope with the problems of a country composed of two entities and three constituent peoples, as they are denominated in the constitutional text. We must admit today that the drafter's imagination served the purpose. Its product may not be superb, but it nevertheless is remarkable for having brought peace to the country instead of warfare. So from Tunisia to Bosnia and Herzegovina, from seeking inspiration for legal transplants to the dialogue of judges, from warfare to overcoming it by constitutional engineering, comparative law has created bridges of peace and reconciliation. It was not its primordial task, but the discipline of comparative law got well adapted to it. May we therefore wish the comparative law a long and fruitful career in the years to come. Thank you.
Thank you very much, Judge Popovic. We'd be very pleased to take some questions and comments. Let's start with this side now, and if you could introduce yourself as well.
Thank you. My question goes like this. One of the resultant effects of migration is putting pressure on Europe. And whoever is a migrant to Europe, Europeans will be forced to provide food, shelter, and by extension, development. So the simple question is going to be, did you think that the policy of the European Union has been favorable? My question is from a perspective. In Africa, for instance, the policy of freighting money from Africa to Europe is as easy as ABC. But if you want to repatriate the money back, it becomes cumbersome. And the resultant effect of that is simply the multiplying effect of that money will be for the development of Europe. Whereas the country where the money came from will be in abject poverty. For instance, my country, Nigeria. And I'm sure if you hear Nigeria, you have to think back and imagine Boko Haram. It has been so arranged to the extent that in Nigeria, they steal what they do not need. One person will steal 100 billion. And to freight it out of Nigeria will be as easy as anything. But to bring it back, it will be difficult. Then whoever has stolen that money cannot even cry out, because in the process of doing that, you'll be intimidated, you'll be arrested, and be prosecuted. So the simple question is, has the European policy been favorable? Let us talk on moral ground. Thank you very much.
First of all, I'm not quite sure whether I properly understood the question. It concerns basically our moral attitude, not the law. Because in terms of law, those who are coming to Europe must be considered under the rules of the international law. And I must tell you, as you have heard from my CV, I'm not an international lawyer. But they are either refugees or they can be asylum seekers. So there is no such category as migrants in terms of international law, at least for the time being. Of course, the actors in international law are free to choose and to create new categories. If I were to sit in a case and decide whether someone is asylum seeker, that is easier, because to become an asylum seeker, you have to be persecuted in your country of origin. That is relatively clear, although not as clear as we can imagine at once. But the problem is whether those people are refugees. And that is where my expertise ends, because I'm not familiar with the Convention on Refugees. And if you ask me for my personal attitude towards the people coming, towards the migrants, I'm very much in favor of the policy of the Bundeskanzlerin of this country, that is the policy favorable to the migrants. Those people, 90%, 95% of those people are poor people who, not in terms of money maybe, but people who escape embattled region, and they should receive our understanding and help. That is my personal opinion, outside the law.
Thank you very much. Is there a final question for Judge Popovic or a comment? Yes, okay, in the front.
Okay. Oh, thank you, Judge. And thank you for this opportunity. I just want to support the idea that legal benchmarking is indeed a great opportunity for creating an opportunity for cultural exchange, because when at the point at which you start implementing these laws, you're able to also draw from the culture within which you borrowed those concepts. I come from South Africa. I know that as part of our research for the Constitution, particularly areas such as the Bill of Rights and the Constitutional Court, we looked at countries such as this one, Germany. The team visited the Constitutional Court here. Canada was one of the countries where we benchmarked our Bill of Rights. And more recently, we also borrowed from several countries my office, which has elements of being an ombudsman, an investigation bureau, and an ethics office. I wanted to say more recently we had a team from this country, from Germany, led by, I think, the president of the Federal Council, that came to my office to look at this office, the Power Protector, with a view to considering it as a vehicle that could be used to strengthen public accountability, but also to strengthen avenues for access to justice for groups that cannot easily go to court when their administrative rights have been infringed. So I just wanted to support that. But then to urge the ICD to create perhaps even more opportunities for beyond benchmarking, just now discussing jurisprudence, not the drafting of laws, but just discussing interpretation of laws, implementations of laws with a view to strengthening the rule of law in our various democracies. Thank you.
I'm glad that someone from South Africa took the floor for two reasons. Firstly, because the jurisprudence of the Constitutional Court of South Africa has on many occasions been an inspiration for the European Court of Human Rights, and you can find references in the judgments. And secondly, because South Africa is somehow in the lead in comparative constitutional law, because there is a provision in South African constitution which makes it obligatory for a sitting judge to consult foreign law, to consult foreign authorities, which does not exist anywhere else. So we can only congratulate South Africans for their achievement. Thank you.
Excellent. Well, on that occasion, I think it's time for us to extend our sincere gratitude, please, to the Honorable Judge Popovic. Thank you very much for the lecture and the keynote.